Can my boss cut my hours without warning? Imagine showing up to work expecting your usual schedule, only to see half your hours gone. No warning, no explanation, just fewer shifts and a smaller paycheck. This happens all the time, especially in retail, food service, and other hourly jobs. But the question is, can your boss legally cut your hours without warning? The answer depends on federal law, state protections, and your own work arrangement. The Fair Labor Standards Act, FLSA, sets minimum wage and overtime rules, but it doesn't guarantee a set number of hours. Most U.S. workers are employed at will, meaning schedules can change. Still, some states and cities have passed predictive scheduling or reporting time pay laws that give workers more protection. In this video, we'll explain what federal law says, how state laws can help when hour cuts cross into illegal territory, and what steps workers can take if their shifts disappear unexpectedly. 1. Federal law. The FLSA and at-will employment. At the federal level, the FLSA covers minimum wage, overtime, and child labor rules. But here's the part many workers don't realize. The law does not require employers to give advance notice before cutting hours. Why? Because most employees in the U.S. are considered at-will workers. That means an employer can change schedules, reduce hours, or even terminate employment at any time for almost any reason, so long as it's not discriminatory or retaliatory. For example, if a restaurant owner sees business is slow and cuts everyone's shifts for the week, that's legal under federal law. The only requirement is that workers must still be paid for the hours they actually work, at least minimum wage, with overtime pay for hours over 40 in a week. So under federal law, a boss can cut your hours without warning. But that's not the whole story, because state and local laws often step in with added protections. 2. State predictive scheduling and reporting time laws. Unpredictable scheduling creates major stress for workers. Some states and cities have recognized this and passed laws to protect employees from sudden changes. These are often called predictive scheduling or reporting time pay laws. In California, if you're scheduled for 8 hours but sent home after 2, your employer may still owe you reporting time pay for part of the lost hours. In New York, retail and hospitality workers must receive minimum pay if their scheduled shift is canceled last minute. In Oregon, large retail, hospitality, and food service employers must give at least 7 days' notice of schedules, moving to 14 days over time. In Chicago and Seattle, Fair Workweek laws require advance notice of schedules and extra pay if employers make last-minute changes. Take an Oregon grocery store worker as an example. If management cancels their shift with less than a week's notice, that worker may be entitled to extra pay under state law. 3. When cutting hours becomes illegal. Even though cutting hours is often legal, there are important exceptions where it crosses into illegal territory. Discrimination. If an employer cuts hours only for certain workers because of race, gender, age, religion, or another protected category that violates federal anti-discrimination laws. Or retaliation. If hours are cut after a worker files a complaint, reports harassment, joins a union, or asserts legal rights, that's unlawful retaliation under laws like the NLRA and OSHA. Contracts or union agreements. Some employees have contracts or collective bargaining agreements that guarantee minimum hours or notice. Employers must honor those terms. Wage theft through underscheduling. If an employer cuts hours but still expects workers to remain on call without pay, some states treat that as wage theft. Picture this. A hotel worker reports unsafe conditions. The next week, management slashes her schedule as punishment. That's retaliation, and it's illegal. 4. The impact on benefits and overtime cuts don't just shrink weekly paychecks. They can affect benefits and long-term stability. Chan's health insurance. Under the Affordable Care Act, employers with 50 or more employees must provide health coverage to those working at least 30 hours per week. Cutting hours below 30 could strip workers of eligibility. Overtime, a reduction in hours may remove opportunities for time-and-a-half pay after 40 hours. Unemployment benefits. In some states, if hours are cut drastically, for example from 40 hours down to 10, workers may qualify for partial unemployment benefits. For instance, if an Illinois worker typically works 35 hours per week but suddenly gets cut to 12, they may apply for partial unemployment since the reduction is substantial. 5. Real-world examples. In Oregon, retail workers used fair scheduling laws to sue after repeated last-minute cuts, winning compensation for lost hours. Mandinam, ACM. In California, a restaurant chain faced fines for sending staff home early without paying required reporting time pay. In a retaliation case, a grocery clerk filed a wage complaint, and management responded by slashing shifts. The worker filed a charge, and the NLRB ordered remedies. In seasonal work, a landscaping company reduced hours in winter. Because the cuts were due to seasonal demand, not retaliation or discrimination, they were legal. These cases show the difference between lawful business adjustments and unlawful retaliation or wage violations. 6. What workers can do. If your hours are cut suddenly, there are steps you can take to protect yourself. Check state and local laws. States like Oregon, California, New York, and cities like Seattle and Chicago give extra protections. Track your hours. Keep detailed records of scheduled shifts, actual hours, and any last-minute changes. Know your retaliation rights. If you recently reported safety issues, discussed wages, or joined organizing activity, cuts may be unlawful. Review contracts or union agreements. These may guarantee hours or notice. Apply for unemployment. If the reduction is significant, you may qualify for partial benefits. Speak up. Some employers don't even realize predictive scheduling laws exist. Raising the issue can lead to corrections. For example, a barista in Seattle noticed her hours suddenly cut. She learned about the city's Fair Workweek law, filed a complaint, and received back pay for the lost shifts. 7. The bigger picture. Why does this issue matter so much? Because unstable schedules create instability in people's lives. Workers can't budget, arrange childcare, or take a second job if shifts change last minute. That's why more states and cities are pushing for fair scheduling laws. Employers argue they need flexibility to respond to customer demand. Workers argue they need predictability to survive. The law is slowly evolving to balance both interests. For now, at-will employment gives employers broad power, but the trend is towards stronger worker protections. So, can your boss cut your hours without warning? Under federal law and at-will employment, the answer is generally yes, as long as you're paid for the hours you actually work. But the real answer depends on where you live and why your hours were cut. States with predictive scheduling or reporting time pay laws may require advance notice or compensation. And if cuts are motivated by retaliation or discrimination, that's unlawful everywhere. The key takeaway is this: don't assume your employer holds all the power. Learn your state's rules, keep good records, and speak up if cuts seem unfair. If this video clarified your rights, share it with coworkers. Knowledge is power, and when workers understand the law, they are harder to exploit.